Hello, friends, and welcome to another WSIB Truth Matters with Joe Machado. Today is the fifth video in the five-part series in the topic that I've been talking about over the last week, which is tribunal jurisprudence. This particular topic, after dealing with the WSIB, both as an injured worker and also on a professional level, having built the largest paralegal firm in Ontario with over $300 million in settlements, both arrears and future benefits. And I say this only because of all of the experiences that I gathered over that period of time. This is the most egregious, sick, ruthless, cowardly, borderline criminal act that the WSIB has ever perpetrated on injured workers, ill workers, and their families. It deals with a matter that really pisses me off. Anytime that I even think about it, I get disgusted and I get angry. And that's the issue of deeming, where if you were granted a future economic loss award at some point under Bill 162, or you were granted a full LOE or LOE benefits, rather, under Bill 99, and where you're not able to go back to your previous job and the WSIB just miraculously plucked something out of the air that you would be able to do and dictated the earnings that you might be able to earn, that's deeming. It's sick what they did to people, and they continue to do to this day with this practice. And it needs to end. And this is why with my firm, WSIBsettlements.com, I've initiated a class action package for those who have been affected by the WSIB's deeming policies. We've had quite a number of people enroll. And if you find yourself in this situation, you owe it to yourself to at least check out what we're doing and why we're doing it, more importantly, because this cannot continue. It's not sustainable. So anyway, in this whole series, five-part series of tribunal jurisprudence, that's Workplace Safety and Insurance Appeals Tribunal jurisprudence. This fifth video, the topic that I picked was loss of earnings, employability, and suitable occupation, because they go hand in hand. And going through this tribunal decision, and I tried to get tribunal decisions that were as close to today's date as possible, because it really continues to demonstrate the drastic line of thinking between how WSIB case managers and appeals officers make decisions and vice chairs and panels with the Workplace Safety and Insurance Appeals Tribunal. In my opinion, oftentimes the case managers, they decide no. I could come up with a number of different reasons why they deny things, and a lot of times they're just puppets, somebody else pulling their strings. And then there's appeals resolution officers in the appeals branch, and in my opinion, I think they're absolutely useless. I think the appeals branch should be gone because it's detrimental to injured workers, and it's one more step in the process that the WSIB controls that only adds time to how long injured workers have to wait to get their issues dealt with. Because when you go to the tribunal, you get your issues dealt with. They're thorough. They pay attention to what they're doing. They look at the policies, they look at the law, they request all of the policies from the WSIB that they think may be applicable to a particular hearing or appeal that they're going to have. And occasionally they will send something back to the WSIB to tell them, you know what, you need to rewrite this because it's totally out of touch with the law or with the intent of whether it be the Workplace Safety and Insurance Act or the Workers' Compensation Act pre-1997. So you only get to see these things if you're dealing with these people on a regular basis. And in my case, because I was building the largest paralegal firm in Ontario, I made it a mission to learn how things were done, who was responsible for making decisions, who were the puppeteers, and what the differences were, the big differences between the Workplace Safety and Insurance Board and the Workplace Safety and Insurance Appeals Tribunal. And one of the distinctive differences is that the Workplace Safety and Insurance Appeals Tribunal has jurisprudence. So these are a body of decisions on a number of issues that many vice chairs or panels concurred with and created this, which now it's called jurisprudence. And when vice chairs are making a decision on a particular issue, they will oftentimes look to jurisprudence to guide them or to make sure that they're in line with what's being done in the majority of vice chairs and panels that are making decisions. And so I don't know why the WSIB doesn't do this, or appeals officers. They're either lazy or just too arrogant, or they think they know better, or it's probably part of a bigger scheme. I could have a talk about that for a long time as well. But vice chairs do that. You know, when they're making a decision, when they're looking at an appeal on a particular issue, they look to see if there's tribunal jurisprudence that they have so that they can look at it and use it in some way with the decision that they're making, because they're trying to be fair and just. That's really what you're going to get at the tribunal. It may not necessarily be what you want. Not everything is allowable. And I've had to say this to my clients over and over many times, but they give you closure, and you can guarantee that they are thorough. They're not just going to give you a 3-paragraph decision and send you on your way and make you feel like you just wasted 1, 2, 3, 5, 10 years of your life dealing with something that just should have never been there to begin with. But we get to see this often with the WSIB. As you can see, friends, I'm starting strong with this one because I'm already pissed off with these MFs in the worst way. So the decision I'm going to be referring to today, and I'm going to put it up I'm going to refer to certain aspects of the decision. I'll put it up on the screen as we go along. It's Tribunal Decision Number 445/21. And it was rendered on June 24th, 2021, so relatively recent. And so in this particular decision, the gentleman, a 54-year-old cement finisher, suffered an injury in 2012 to his left arm, and included his shoulder as well. And I don't know if any of you are familiar with cement finishing, but it's a difficult job, and you need both of your shoulders and arms, and they need to be strong to do your job. And he was granted a 13% non-economic loss award, so some restrictions were considered and accepted. And unfortunately, the employer went out of business, and he was unsuccessful in obtaining suitable employment, despite, however minimal, the board provided. But I'm just going to put this up on the screen here because you need to see how a board the WSIB, it's case manager and then the appeals resolution officer, because they both sided with this asinine, stupid, ridiculous line of thinking. So anyway, here you go. It's up on the board, on the screen. Sorry. So the operating area of the Workplace Safety and Insurance Board, in a decision dated July 26, 2019, determined that the normal functional precautions for an upper extremity injury of the nature sustained by the worker, full tear of the supraspinatus tendon, were to avoid heavy lifting, above shoulder work, and repetitive work with the arm away from the body. No kidding. Doesn't take an Einstein to figure that one out. Given such precautions, it was determined that the worker would have been fit to perform duties as a light-duty cleaner. Where do they come up with that one? Because you don't need your shoulders and your arms to do that. Which did not require any upskilling or schooling. That a way to just really push you down further in the gutter. In that SO, suitable occupation, the worker could have earned entry-level wages in October of 2013, the minimum wage of $11.25 per hour. Just listen to how ridiculous this sounds. The worker could have earned, as if they had a guaranteed job for him, and in a specific date in October of 2013, minimum wage. As a result, the worker was entitled to partial LOE benefits from October 11, 2013, based on the ability to earn minimum wage in the SO for a 40-hour work week. I don't know. I don't understand where they come up with this shit. It's mind-boggling. How? I don't think a rationally minded person that could string two thoughts together could ever come up with such a ridiculous proposition. But anyway, he had a very good rep or representative. And I want to read out the crux of the argument that his representative made. I'm going to put it up on the screen here. On behalf of the worker, it was submitted that the identified SO, suitable occupation, of light-duty cleaner was not suitable, and the worker was not competitively employable for a number of reasons. The worker's age, his permanent restrictions, his lack of education, his inability to read or speak English. How's he going to find a job? His lack of transferable skills other than in the construction, and lack of any training or assistance from the board meant that the suitable occupation of light-duty cleaner was not suitable and the worker was competitively unemployable. So they miraculously came up with all of this crap that he could do when he couldn't even write or read or write English. So how's he going to find a job? I mean, I'm an employer. Somebody came in and applied to work for me, even if it was just cleaning offices. I mean, if they couldn't get through the interview with just a bit of conversational English, I probably would have an issue. There's all sorts of reasons and legal ones why I would have an issue with that. And believe me, when I had my company, I hired a lot of injured workers, and I trained some actually to become to work for my company in either marketing or support or as a file assistant whenever I could. But to expect somebody who has no experience in a particular job market, in a particular occupation, and just say, here, off you go. Go look for a job, light cleaning, and you should be able to earn minimum wage, 40 hours a week, and good luck, and have a happy future. It was further submitted that the worker met the criteria established by tribunal jurisprudence for a determination that he was competitively unemployable. Now, this is the crux of the matter, and this is where tribunal jurisprudence can be very supportive. It can be your friend when you're arguing a case or submitting a case. As a result, it was submitted that the worker was entitled to full loss of earnings benefits from the date of his layoff, October 11, 2013, to the date of his final LOE review, November 28, 2018, and full loss of earnings from November 28, 2018, until the worker reached the age of 65. Well, of course, I mean, what other conclusion could you make? Especially since the WSIB didn't even offer any support to help him in his new goal, not his goal, their goal. They pulled that shit out of the hat and said, here, this is what you're going to do now. I like it when tribunal vice chairs put the WSIB people in their places. And I've seen a lot of it, and I always get a good chuckle out of it, because I know I can read between the lines, and I'm thinking, yeah, this is a fuck you. Okay, just in case you didn't really understand it, let me repeat it. This is a big heaping pile of fuck you, and go learn how to do your job. And the vice chair did just that, not so eloquently as I just put it, but in terms that the WSIB could understand. So I'm going to put this up on the screen so you can see the vice chair's conclusions. And so basically, vice chair starts, tribunal jurisprudence with which I agree and adopt evaluates employability and considers the nature of the compensable condition, the worker's age, level of education, transferable skills, and literacy, rather than focusing on whether the worker was totally disabled, which is often what the WSIB focuses on. Other tribunal jurisprudence notes that factors for consideration also include medical restrictions, pre-existing conditions, and English language ability. See, for example, decision 1214/15. Now, here's where it gets really, really nice. In this case, although the worker may only physically be partially impaired, I find he is competitively unemployable, as he has no real prospect. This vice chair lives in the real world like the rest of us do, of being able to obtain or maintain employment in the board designated, I call that pulling out of the hat, suitable occupation, or the labor market in general. I find that the cumulative effect of the worker's compensable condition and resulting physical limitations, his age, his lack of education and transferable skills, his lack of job search skills, and his literacy and language skills have significantly impacted his ability to obtain employment, such that he is competitively unemployable. Go figure. The vice chair looked at all of the same facts that the case manager and the appeals resolution officer did. I continue. In other words, I find that the worker's compensable injury and his personal and vocational characteristics contributed significantly to his ongoing loss of earnings. I find the loss of earnings arose from his compensable injury. As a result, I am satisfied that the worker was unable to earn any income in any suitable modified work due to his compensable and permanent condition. Accordingly, I find that the worker is entitled to full LOE benefits under Section 43 from October 11, 2013 until November 28, 2018, and from November 28, 2018 until the worker reaches 65 years of age. The only thing you could do that would be just, that would be fair, and you don't need to rewrite the law. The vice chair didn't need to rewrite the law. Section 43 of the Workplace Safety and Insurance Act does provide for the authority for the WSIB to make that same decision. So it's not like the vice chair went out and created some ambiguous policy and all of a sudden said, well, you know, the WSIB policies that they have in place and the Act, they don't really meet this particular situation. So let me create something to allow me to give this person what they're entitled to. No. Section 43 of the Act did provide for that. It's just that the WSIB case manager and the useless appeals officer didn't bother to consider the facts, look at the law with a willingness to be fair and say, hey, I can do this. I can do this for this person. And that's what I'm going to do because the law authorizes me to do that. Friends, I really hope that you enjoyed watching the previous 4 videos. If you haven't, I strongly urge you to view them, even if you don't think it applies to you, because I believe that there's something to be learned in every instance. And you will learn something from each one of the 4 previous tribunal decisions that I looked at that dealt with the particular issue where there was tribunal jurisprudence and where the vice chair relied on that tribunal jurisprudence to make a decision. I hope you enjoyed this one. And I do appreciate that I threw a couple of the big F's out there, but I'm sorry. Actually, I'm not going to apologize for it because it's just the only way that really exemplifies the absurdity of how these idiots come up with this shit and put people's lives. He was injured in 2012. He was reduced to minimum wage in 2013. His decision, the tribunal decision, was made in 2018, 5 years later, and it probably took some time for the board to do their little fucking dance to implement that decision. And him and his family had to go without for a long period of time where they shouldn't have. This is negligent because if there's a law that authorizes you to do something and you don't do it, that is negligence. You put these people through difficult times, and who knows what happened in their lives in that interim time that these people didn't apply the law properly. And if they didn't apply the law properly because they don't know about it, then they shouldn't be there. And you probably have a similar situation to this one, or you know somebody who does. And there's only one way to stop this shit, and that's taking them to court. So have a look at what we're doing at WSIB Settlements on that regard. And also, over the years, I took all of the experience, all of the wins, and the losses, and I put together a package with tools, specific tools, useful, that you can actually use to help you with your WSIB case, regardless of where you are in that process right now, at WSIBsettlements.com, and you get to access all of that with our first of a kind, and the only one that I'm aware of, app, where it's all there at your fingertips. Anybody can use it, no special skills in computers or no special English skills or age, no challenges whatsoever. You can do that. And our docs that address every single issue that could possibly arise in a claim, from pre-90 to Bill 162 to Bill 99 claims. I put together these docs. They're legal documents that I put together with arguments that work in every issue that can come up. And you can access your own and download it and upload it to the WSIB in less than 5 minutes. That's how easy the process is. So I invite you to go there and have a look. Friends, if you're not already subscribed to the channel, I invite you to become a subscriber. Thank you for my subscribers. It means a lot. The channel's grown. It's amazing in 4 months how much we've accomplished, how many people I've already been able to help. It really makes me feel good. It rejuvenates me. It makes me feel young, because anytime I go at the WSIB or I get a tool in somebody's hand to go at them and they can win, it's a win. And I like winning against those people because they're losers. Right down when it gets to the crux of the matter. So yes, it's free to subscribe. You just click the subscribe button, and that's it. You get notified every time I come out with a new video. I've got, I think, 74 or 75 videos right now that I put together in the last 4 months, and I've got tons more up here of information that I gathered over the course of 30 years to help injured workers become successful in their claims and to give them closure. And if you're barking up the wrong tree, so to speak, I'll be the first one to tell you, because there's nothing worse than having false hope, and at the end of the line, nothing happens. So friends, and please share my videos with others. I know there's thousands of injured workers throughout this province that are getting screwed right now, okay, by these people. And these are my views. I express my views based on what I see, what I hear, and all of these years of experience. But I believe there's a lot of people out there getting screwed right now. And the WSIB is working on another project with this KPMG report to put the screws even further to injured workers. But we've already adjusted to that on WSIBsettlements.com, because whatever appeal deadline they impose on injured workers, we can make sure that you meet any appeal deadline, even if it's a 24-hour appeal deadline, you can meet that, because we've adjusted our program to make sure that you can do that. So they can toss anything they want at us. They can regurgitate all of the garbage that they've been tossing over the last 30 years. We're ready for them. So yes, share my videos. You may get it to somebody who really needs help. Maybe they're embarrassed to talk about it. Maybe financially they can't. And the program we have it costs next to nothing. And it's a lifeline for them. So please share my videos with others. And give me a thumbs up if you like my content. If there's something in particular that you would like me to talk about, and it isn't in one of my 74 videos, let me know. Send me an email at joemachado@wsibsettlements.com. Let me know what it is, and I'll work it into one of my videos. If you have any questions about this particular decision or others or any other subject relating to the WSIB, by all means, use that email and send me an email, and I will get back to you. As always, friends, it's been an amazing ride for me. I didn't think that I'd get this far in a short period of time, 75 videos, over 100 subscribers. I just want to touch every injured worker out there in this province. Let them know that we can help, that there is help, that they don't need to take it alone, that there is help for them. And coming up on Monday, something that I haven't done in a while, is I'm going to be answering viewer and subscriber questions. So I already have some interesting ones. And if you're watching this video and you have a particular question that you have, just give it to me on the comments or send me an email, and I'll answer it in on Monday, on my Monday's video. All right, friends, thank you for taking the time to watch this video. And I hope that you learned something here. And I hope that you keep coming back to watch my videos. As always, friends, take care now.